Sarah, the Supreme Court has ruled on this issue. What have they decided?
What they decided to say here is that essentially the fraud analysis doesn't apply in a case here where there's condom use, so non-consensual, non-condom use. Instead, what they're saying is that it essentially nullifies any consent to the sexual activity in question, rather than having to apply a fraud analysis and have to prove that there was some attempt to deceive, as well as some potential deprivation on the part of the complainant. They've applied a much more straightforward test. And I think that that's quite welcome for many different people in the community, as well as organizations. And even from a legal perspective, it tends to make things a little bit less complicated.
So, Rachel, anything you want to add about the Supreme Court's finding here? And kind of as the takeaway, does this mean that if your partner asks you to wear a condom and you don't, or you take it off, is that now sexual assault?
It is definitely sexual assault. And that is the takeaway exactly, Christine. And I think it's a great takeaway. I think that it very much is a very different sexual act if you're having sex with a condom versus without a condom. And that's exactly what the Supreme Court ruled, that if someone consents to having sex with a condom, and if then someone takes it off or doesn't respect that wish, that is sexual assault, because that behavior goes to the heart of what the person did or did not consent to.
Sarah, what happens next for the accused here, Kirkpatrick? The court has said they haven't decided on his, guilt or whether he should be acquitted. They've sent it back for a new trial. So why is that?
That's right. So I expect that this will proceed to a new trial. Essentially, the court has held that we need to have a new trial here so that we can properly analyze the issues at play and make sure that the law is being properly applied. It will be, of course, at Crown discretion as to whether or not to continue to proceed, given a number of factors, including the passage of time. But I expect that this matter will find itself before the courts again.
So, Rachel, in this case, the accused, as we discussed, wore a condom the first time, but not the second. And obviously, as we discussed, the amount of time that had passed in that case between the first and second time was not very long. It was a few hours. And the court found that there was evidence that the complainant did not consent to the sexual activity in question there, condomless sex. But how would that principle apply going forward? It's sort of like a one-time assertion of a condom condition always stand? Is it a condition every time until the requesting partner expressly says it's no longer required? Does it need to be reasserted, or is it just a standing condition then?
So I think that's a great question. I think the fact that now the Supreme Court has said that condom use and not condom use, that's an essential aspect of a sexual activity. That is a sexual activity, and that needs to be consented to. I think now the standard that we have to go to is a standard of Barton, where the Supreme Court held what consent means. And they said it doesn't matter what the relationship is between the two people. It doesn't matter if you think that there's implied consent, there isn't. Every time that two people engage in sexual activity, there has to be communicated affirmative consent. And that goes for condom use as well. If you're okay with someone not using a condom, or if you want to ask someone if they're okay with not using a condom, that has to be specifically communicated in the affirmative. Someone can't say, well, there was not really any mention of it, or I didn't think this, or some time had passed and maybe the second time they didn't care to. No, I think now that there's been a ruling that it does form part of the sexual act itself, there has to be that express communicated consent that I'm okay with having sex without a condom. Absent that, it's not okay.
Sarah, does the level of sort of assertiveness about how clearly this complainant in this case was so explicit in her desire to have a condom, does that matter at all? Does a more casual assertion of I'd prefer if you use a condom, is that the same value, or is it identical, or is it different at all? She was very insistent in this case.
Yes, absolutely. And I do think that that helped the court in reaching their decisions here where we didn't have previous jurisprudence on the issue, really. I echo many of the things that Rachel has expressed here. I think that, it is something that is going to now play into the analysis about the type of sexual activity, the quality of the sexual activity in terms of what that is and what it entails, which goes to issues of consent. Now, perhaps we can have accused people mount
Right.
a defense of honest but mistaken belief in consent.